Okay, let's unpack this. Imagine you're grappling with a complex legal question. Do you picture a perfectly ordered rule book, just waiting for the right answer?
Or maybe something more fluid.
Exactly, constantly shifting and evolving.
What's fascinating here is how often we assume, that law is this fixed system of clear rules applied neatly by a judge,
Hmm.
but our deep dive into legal reasoning reveals it's a far more dynamic and, frankly, ambiguous process than most people realize.
Yeah, it's not quite so black and white. Today, we're pulling back the curtain on this intricate world. We're drawing powerful insights from Edward Hirsch Levi's An Introduction to Legal Reasoning and Phoebe C. Ellsworth's Legal Reasoning.
Two really key texts.
Absolutely.
Mm.
And our mission for you is to uncover how law truly evolves, how it adapts to new situations, societal shifts, and why that very ambiguity isn't a flaw, but maybe an essential feature.
hmm
You'll discover not just how judges think, but how the law itself is in a constant, fascinating dance with reality.
A dance is a good way to put it.
So, if the law isn't just about applying unchanging rules, what is its fundamental way of operating? How does this dance begin?
Well, Edward Levi describes the basic pattern of legal reasoning as reasoning by example, or you could say case-to-case reasoning. It's built on the doctrine of precedent, that foundational idea, that courts should generally follow rulings from previous similar cases.
Right.
And this process unfolds in three key steps. First, a similarity is observed between a new case and a past one.
Right.
Second, a rule of law from that first case is identified or maybe announced. And finally, this rule is then applied to the current similar situation.
Okay, here's where it gets really interesting and perhaps a bit counterintuitive for some. You might assume that once a rule is established, it's, well, set in stone.
Yeah, that's the common assumption.
But our sources suggest the opposite is true.
That's right. If law were simply about applying general unchanging rules to diverse facts, it would be quite unsettling. It's disturbing even to find that these rules actually change. They get remade with each case. Yet Levi argues this constant remaking is the indispensable dynamic quality of law. The true meaning and scope of any legal rule depend entirely on how courts determine what facts are similar or different to prior cases.
Hmm.
That subtle distinction finding similarity or difference, that's the critical pivot point.
So it sounds less like a rigid logical deduction and more like, well, trying to find a pattern in a landscape that's constantly shifting.
It absolutely is. And this is why Phoebe Ellsworth points out a crucial difference between judges and scientists. You see, while a scientist might analyze inconsistent data to derive a general principle,
Okay.
a judge starts with a specific situation. They look at its similarities and differences to past cases, and then they decide a specific outcome. They're kind of working in reverse, if you will.
Right, applying precedent, but also shaping it. So it's not just the judges doing the shaping. Lawyers, too, are actively involved by presenting these competing examples and analogies. They're a part of this dynamic.
Precisely. The legal forum, the whole adversarial system, demands the vigorous presentation of competing examples and arguments. The rule that ultimately emerges from a case is really a creation of this process, where opposing viewpoints are thoroughly argued out.
So everyone's involved.
Right. This means that both the parties involved, through their lawyers and the court itself, are active participants in the ongoing work of lawmaking. It's not just finding the law, it's making it, in a sense.
This idea, though, of rules changing as they're applied rather than being fixed, it might feel a bit unsettling to some people listening. It kind of challenges our perception of law as this inherently stable thing.
Oh, definitely. It certainly runs contrary to the pretense of the system, as Levi puts it. We like to think of law as clear and certain, but the very mechanism of legal reasoning accepts the differences of view and ambiguities of words. Legal rules are rarely, if ever, truly crystal clear. Think about it. If they had to be perfectly defined before being applied, society simply couldn't function.
So ambiguity isn't a flaw to be eliminated, but actually a necessary feature. Is that what you're saying?
Indeed. It creates what Levi calls a gap of ambiguity, which is vital. Why? Because it allows for discussion of policy and the participation of the community.
Okay, that makes sense.
This isn't just theoretical. It's what makes peaceful adaptation possible in a changing society. This fluidity allows new ideas to be infused into the law, enabling it to respond to changing societal wants and evolving needs without needing constant legislative overhaul for every little thing.
That paints a picture of constant evolution, definitely not a static rule book.
Right. Levi describes it as a kind of circular motion in the creation of legal concepts. First, as new cases are compared, the court might, fumble for a phrase, slowly building new concepts.
Trial and error, almost.
Sort of. Then, that concept becomes more or less fixed as reasoning by example classifies new situations, putting them either inside or outside its boundaries. But eventually, the concept can break down. Maybe the reasoning is stretched too far, and its original suggestive influence just isn't desired anymore.
Right. It stops fitting the new realities.
Exactly. And at this point, there's often an attempt to escape to some overall rule, some grand principle. But Levi observes these grand rules are often, well, useless, and maybe just window dressing.
It sounds remarkably similar to how everyday language evolves, doesn't it? Words and concepts are constantly redefined by how we use them in new contexts.
Absolutely. It's a bit like Judge Cardozo's famous observation that a word starts out to free thought and ends by enslaving it.
Interesting.
This evolution is constant because society is dynamic. New situations arise all the time, and people's needs and desires shift. The law has to keep up somehow.
Let's ground this fascinating, maybe slightly abstract idea in a concrete example. You've brought us a historical journey looking at the concept of dangerous articles in case law from the 19th and early 20th centuries. It seems to illustrate this dynamic evolution perfectly.
Yeah, this historical arc truly showcases how reasoning by example works in practice. It started way back in 1816 with a case called Dixon v. Bell. The owner of a loaded gun was held liable after it caused injury.
Okay, simple enough.
Right. This case essentially established a legal category. If an article is inherently dangerous, the owner is liable. Seems straightforward.
So if it's dangerous, you're responsible. Got it. But then things got complicated pretty quickly, didn't they?
Oh, very quickly. Just 5 years later, you have Winterbottom v. Wright. A coachman was injured by a defective coach. But here, the court refused to hold the coach provider liable.
Why not?
They worried about absurd and outrageous consequences if liability were extended so broadly. So they explicitly refused to call a coach a weapon of a dangerous nature. The concept was immediately narrowed.
So a loaded gun is dangerous, okay, but a coach isn't. The lines are already being drawn, but they weren't always clear, were they? It seems a bit arbitrary.
Not at all clear, and yes, it can seem arbitrary at first glance. Fast forward to 1852, Thomas v. Winchester. This involved mislabeled belladonna poison. Mrs. Thomas suffered terribly,
Oh, dear.
and the court allowed her to recover. They reasoned that the defendant's negligence had put human life in imminent danger. So this was like the loaded gun case. The item created imminent danger. Poison was in the imminently dangerous category, but the defective wagon was still out.
Okay, so the category is shifting. And this imminent danger concept, it started to expand its reach, gradually including more and more items over time.
Precisely. By 1869, in George v. Skivington, a chemist was held liable for injuries from a, believe it or not, secret hair wash.
Hair wash? Seriously?
Seriously. The court equated it to a defective gun, stating that if you just substitute the word negligence for fraud, the analogy was complete. So now, loaded guns, defective guns, poison, and even hair wash were deemed imminently dangerous.
Wow.
Meanwhile, defective wagons and lamps remained outside the category. The category is definitely expanding case by case.
It sounds like the legal system was really grappling with how to apply this evolving principle to a changing world, constantly shifting the boundaries.
That's exactly it. You see the struggle. A defective balance wheel for a circular saw was deemed not imminently dangerous by one New York court.
Okay.
Yet, just a few years later, in 1882, a builder of a scaffold was held liable when it collapsed and killed a painter. So boom, scaffolds get added to the imminently dangerous list.
Right.
We even see an exploding aerated water bottle and defective coffee urn eventually joining this dangerous category later on.
So the lines were getting incredibly blurry. I mean, hair wash, coffee urns. What was the underlying tension they were trying to resolve here? Was there a guiding principle?
Well, courts tried to distinguish between inherently dangerous, meaning the article was dangerous by its very nature, like that loaded gun.
Okay, makes sense. And imminently dangerous, where negligent construction or handling made an otherwise maybe non-inherently dangerous item perilous in that specific situation. The dangerous class grew to include things like loaded guns, mislabeled poison, hair wash, scaffolds, coffee urns, aerated bottles.
It's quite a list.
It is, but carriages, lamps, balance wheels, and boilers remained in the not dangerous class, at least for a time.
This constant push and pull, this expansion and contraction, It brings us to a landmark case, doesn't it? One that
Right.
fundamentally redefined this entire area of law.
Yes, absolutely. McPherson v. Buick Motor Co. in 1916. Justice Cardozo delivered a really pivotal opinion here. He declared a defective automobile, a vehicle propelled by explosive gases, remember, to be inherently dangerous.
Even though it wasn't a gun or poison.
Exactly, even though it wasn't like those earlier cases. And Cardozo's statement here is truly impactful. Precedents drawn from the days of travel by stagecoach do not fit the conditions of travel today. He's almost explicitly saying the law must adapt to new technology, to new realities.
He absolutely recognized that need for evolution. He asserted that the idea that danger must be imminent, that doesn't change. But, he said, the things subject to the principle do change.
Ah, okay.
He acknowledged that previous cases, like those involving the scaffolds and coffee urns, had already extended the rule of Thomas v. Winchester, and his court was, quote, committed to the extension. No turning back.
And the practical outcome was that the list of dangerous things just kept growing, reflecting these societal changes. Automobiles were becoming common.
Cardozo himself noted this expansion. He observed that the things classified as dangerous have been steadily extended, till they include a scaffold or an automobile.
Right.
Or even pies and cakes, he adds, when nails and other foreign substances have supplied ingredients not mentioned in the recipes of cookbooks.
Pies and cakes.
Yep. He famously described this entire legal process as one where logic and utility still struggle for the mastery. This whole historical arc, it just vividly demonstrates how legal concepts expand through reasoning by example, allowing the law to encompass previously innocuous items as society's views and needs evolve.
We've seen how fluid and adaptable judge-made case law can be. It really does seem like a dance. But what happens when Congress or a legislature writes down specific laws, statutes? You'd think those carefully chosen words would be fixed, offering much less room for interpretation, right?
One would certainly hope so, or at least think so. The words of a statute are not dictum, meaning they are the direct authoritative pronouncements of the legislature, not just, side comments by a judge.
Right, they're the law itself.
And they express the will of the legislature. So courts are generally seen as less free in applying a statute than in dealing with case law. They're supposed to be interpreting the original intention of the legislature when the law was passed.
Okay, so what does this all mean for you listening? Is there actually less ambiguity when judges interpret statutes compared to case law?
Well, paradoxically, no. Levi highlights that ambiguity is inevitable in both statute and constitution, as well as with case law.
Even in statutes?
Even in statutes. What the legislature intended is often ambiguous. I mean, in a significant sense, there's often only a very general intent. And this isn't necessarily because of poor drafting.
Oh.
Think about it. Legislatures aren't fact-finding bodies like courts. They don't typically decide the precise effect of a bill until a specific situation comes up that demands it. And frankly, ambiguity is often key to political compromise. It allows a bill to pass when different members have quite different understandings of its ultimate scope.
That makes a certain political sense, but it sounds like it still gives courts a significant amount of power in shaping the actual meaning of a law, even if they claim they're just uncovering legislative intent.
Exactly. If courts feel free to constantly reinterpret legislation by claiming they've found a new understanding of legislative intent, they can effectively escape from prior cases that interpreted the same statute.
Ah, okay.
And this creates a danger, as Levi points out, because it kind of relieves the legislature from pressure to revise the law themselves if it's not working or needs updating. It shifts the responsibility.
Right. The courts end up doing the legislature's job, maybe?
In a way, Levi argues that once a decisive interpretation of a statute's direction is fixed by the courts, they should generally adhere to it, for legislative consistency. Though he notes judges frequently rebel against this hard doctrine, they don't always like being bound by past interpretations.
This brings us neatly to the Mann Act, which sounds like it really highlights the struggle between supposed clear legislative intent and this evolving judicial interpretation.
Oh, it's a classic example. The Mann Act, officially the White Slave Traffic Act, passed in 1910. It prohibited transporting women across state lines for the purpose of prostitution or debauchery or for any other immoral purpose.
Okay, white slavery. That sounds like a specific target.
Yes, its initial, widely understood intent was clearly to combat organized white slavery, which is a huge social concern at the time. Exploitation, trafficking rings, that sort of thing.
But its interpretation certainly didn't stay so narrowly focused on organized trafficking, did it?
Far from it. Pretty quickly, in Hoke v. United States, 1913, the Supreme Court upheld its constitutionality. They reasoned by analogy to other federal powers, like regulating lotteries, emphasizing systematic enticement and enslavement.
Okay.
But then, just 2 years later, in United States v. Holt, 1915, the court held the act wasn't confined only to cases where the woman was practically a slave. They even suggested it could apply to a professional prostitute if she simply initiated the travel herself. The scope was already broadening significantly.
Then came the Caminetti cases in 1917, which really seemed to expand the act's reach dramatically. What was the core of that decision? How did they justify it?
In the Caminetti cases, the Supreme Court took that phrase "for any other immoral purpose" and applied it to include transportation for things like paid cohabitation or becoming someone's mistress, even when there was no evidence of organized traffic or commercialized vice.
So just personal relationships, essentially.
If they were deemed immoral, defense counsel argued forcefully that the legislative history showed only commercial traffic was intended. They even pointed to an attorney general communication suggesting it didn't regulate voluntary prostitution.
But the court didn't buy it.
No, the court rejected these arguments. They focused on the plain meaning of the words "any other immoral purpose." They argued the common thread, the nexus indicative of the genus, was simply sexual immorality, regardless of whether it was commercial or forced. Justice McKenna famously dissented, warning this broad construction would empower blackmailers.
Right, using the law for personal vendettas. So the court took a very literal interpretation, expanding the law well beyond what many initially thought was its original purpose. The plain meaning trumped what seemed to be the clear historical intent.
Exactly. It effectively swept in all acts commonly thought to be sexually immoral at the time.
Yeah.
That initial, powerful image of women under control of keepers had apparently disappeared from the court's focus. Then, fast forward to 1944. Mortensen v. United States seemed to signal a kind of revolt against Caminetti. In a close 5-4 decision, the court refused to uphold a conviction for transporting prostitutes on what they called an innocent vacation trip.
An innocent vacation.
Well, that was the framing. They cited fear of blackmail and seemed to call for a return to Congress's original intent to eliminate white slavery. What's deeply ironic, though, is that the Mortensens actually ran a house of prostitution. Their case was arguably more commercial than the Caminetti situation, yet the court still ruled against conviction here.
That is ironic. So it wasn't a clear reversal then. And the ambiguity, as you noted, continued even after that brief revolt, didn't it? The meaning wasn't settled.
No, not at all. Just 2 years later, in United States v. Beach, the Supreme Court reversed an appeals court decision. They held that even a short taxi trip for prostitution within Washington, D.C. was covered by the Mann Act.
Even within D.C., not crossing state lines.
Right. This was despite legislative history suggesting local matters were meant to be excluded, and despite a quarter-century of the government not enforcing it for purely local transport. It just perfectly illustrates the ongoing ambiguity and the constant struggle to fix meaning, even when you're dealing with written statutes. The words on the page don't always end the debate.
If statutes, which are supposed to be specific, can be this fluid, I can only imagine what happens with something as fundamental and broadly worded as a nation's constitution. It feels like the ultimate canvas for interpretation.
Absolutely. And we connect this to the bigger picture. Levi argues that under the U.S. Constitution, the court actually has greater freedom to interpret than it does with statutes or even typical case law.
Greater freedom than with statutes. How so?
Because they have the power to disregard prior constitutional cases. Justice Frankfurter put it very powerfully. The ultimate touchstone of constitutionality is the Constitution itself, and not what we have said about it.
Wow. So past interpretations aren't as binding. Why is the Constitution treated so differently in terms of precedent? Why allow such flexibility?
What Levi suggests is a change of mind from time to time is inevitable with a written Constitution. It's designed almost intentionally to embody the often conflicting ideals of the community in ambiguous categories, precisely so it can endure through massive societal change.
So the ambiguity is baked in, by design almost.
You could argue that. Neither the framers nor the court itself can definitively bind its meaning for all time. And paradoxically, the very reverence we hold for the Constitution, what some call Constitution worship, actually gives the court great freedom to, quote, abandon what has been said in order to go back to the written document itself. They can always appeal back to the original text over past interpretations.
That sounds like an almost revolutionary power, allowing for significant fundamental shifts in legal understanding over generations.
It really is. The Constitution cannot prevent change, Levi says. Indeed, by permitting an appeal to the Constitution, the discretion of the court is increased and change made possible. Ultimately, he notes, the ultimate protection is to be found in the people themselves. It's a living document whose meaning is continually negotiated by the courts and indirectly by society.
Let's look at the Commerce Clause. That's seen some of the most dramatic shifts in interpretation over U.S. history. It seems like a perfect illustration of this constitutional fluidity.
Oh, definitely. The Commerce Clause, which grants Congress the power to regulate commerce among the several states, has been a constant battleground over the scope of federal power. Early on, in Gibbons v. Ogden, 1824, Chief Justice Marshall gave it a very broad interpretation. He said it encompassed all commercial intercourse, which significantly expanded federal power right from the start.
Okay, broad interpretation early on.
But then, later in the 19th century, you get cases like Kidd v. Pearson, 1888, and especially United States v. Knight, 1895, the Sugar Trust case. These decisions sharply distinguished manufacture from commerce.
Separating making things from selling them.
Exactly. They said production, manufacturing was a purely domestic concern left to the states, thereby limiting federal power under the Commerce Clause quite significantly.
So a clear swing towards limiting federal reach back then. How did the pendulum eventually swing back in the other direction towards more federal power?
A new concept began to emerge, which sounds a bit strange today. Moral pestilence. This idea started to expand federal power again under the Commerce Clause.
Moral pestilence.
Yeah. In the lottery cases, 1903, the court upheld Congress's power to prohibit lottery tickets from interstate commerce. The reasoning was that the widespread pestilence of lotteries justified federal action, even though lottery tickets themselves aren't exactly, commercial goods in the traditional sense.
Right. It's about the perceived harm.
Exactly. This introduced the groundbreaking idea that Congress could regulate things useless or inherently harmful moving across state lines. And this paved the way for later laws, like the Mann Act we just discussed.
Okay, so using the Commerce Clause for moral regulation, essentially, and this bad articles or moral pestilence concept allowed federal power to continue its expansion.
Precisely. The category of things Congress could regulate based on some anticipated evil just grew. By 1937, in Kentucky Whip and Collar Cone v. ICR Cone, the court upheld a ban on shipping convict-made goods in interstate commerce. And they explicitly compared these goods to lottery tickets, to the immoral purposes targeted by the Mann Act, and even to stolen automobiles. The notion of what Congress could regulate in interstate commerce was clearly expanding beyond just traditional goods and services, to the purpose or the nature of the items being shipped.
This all seems to build inevitably towards the dramatic period of the New Deal, where the court's interpretation of federal power faced immense pressure to adapt to economic crisis.
It absolutely does. The court had initially been quite conservative on economic matters, remember. They'd even held minimum wage legislation for women unconstitutional earlier.
Right.
But by the mid-1930s, under significant public pressure, and of course the backdrop of President Roosevelt's controversial court packing plan proposal.
The threat to add more justices.
Exactly. A major shift was indeed underway. Though Levi actually argues that, given the scale of the Depression and societal changes, a shift was probably inevitable anyway, court packing threat or not.
And this monumental shift led to a major reversal, didn't it? A complete rethinking of the Commerce Clause's limits.
It really did. In United States v. Darby, 1941, the Supreme Court explicitly reversed Hammer v. Dongenhart. That was a famous or infamous case from decades earlier that had struck down federal child labor laws.
A huge deal to reverse that.
Massive. The court, now explicitly viewing the Constitution as a growing instrument, powerfully leveraged the judicial gloss, that layer of interpretation built up by those illicit articles cases we talked about. Lottery tickets, white slavery, stolen goods.
Right, the moral pestilence cases.
They used that precedent to broadly expand the Commerce Clause's reach into economic regulation. The previous somewhat artificial distinction between things harmful in themselves and other commodities was basically just abandoned.
So if I'm understanding this correctly, ordinary commodities, things not inherently harmful like poison or guns,
Right.
could now be regulated by Congress under the Commerce Clause, maybe based on the conditions under which they were produced, even if the harm, like low wages or child labor, occurred locally within a state?
Precisely. As long as those goods eventually entered the stream of interstate commerce. This historical trajectory in constitutional interpretation, much like the evolution we saw with dangerous articles in case law, just demonstrates again how legal concepts expand through reasoning by example, reflecting profound societal changes and, in this case, a vastly increased scope of perceived governmental responsibility.
This deep dive has really shown us that legal reasoning is far more complex than just, pulling a rule from a book and applying it. It really is this dynamic, intricate dance between facts, evolving rules, and these underlying societal values.
Indeed. And Phoebe Ellsworth, in her work, emphasizes that when we talk about legal reasoning, we're predominantly talking about how judges reason, especially appellate judges.
Not lawyers or jurors.
Well, lawyers are advocates, pushing a particular side. Jurors interpret facts within the framework the judge gives them. But judges are the ones tasked with seeking out and applying the appropriate legal authority, and crucially, providing clear, written reasons for their decisions. That justification is key.
Thinking back through history, though, was there always this understanding of how judges actually reasoned? Or did these views evolve over time as well?
Oh, the views definitely evolved. There was a significant shift. If you go back to the late 19th century, Christopher Columbus Langdell championed what became known as legal formalism.
Formalism, okay.
He viewed law almost as a science, like geometry, a deductive system with a neat pyramid of rules flowing logically from these abstract first principles all the way down to specific case holdings. For him, the law library was the laboratory, and the judge's job was simply to discover these pre-existing rules hidden within earlier judges' writings.
Like finding the right answer that was already there. But this formalistic view certainly didn't go unchallenged, did it?
Not at all.
Yeah.
It faced significant criticism. Oliver Wendell Holmes Jr. famously declared in a line everyone quotes, "The life of the law has not been logic, it has been experience."
Right. Experience, not just logic.
He, along with other influential figures like Roscoe Pound, Carl Llewellyn, Benjamin Cardozo, they strongly argued against formalism. They posited that legal principles aren't simply discovered, like scientific laws. They're often created by judges.
Created?
Yes, created, or at least significantly shaped, often influenced by the judge's own sense of what the right outcome should be. They highlighted that abstract general principles do not decide concrete cases, and that even the most diligent research wouldn't always yield one single definite answer in truly complex, contested cases.
This sounds like the birth of legal realism, a movement that really shook up legal thought in the early 20th century.
It absolutely was. Legal realists argued that law is less about abstract logic and much more a reflection of real-world forces, historical, social, cultural, political, economic, even psychological factors.
All the messy stuff.
All the messy stuff. Roscoe Pound's sociological jurisprudence, for instance, directly pushed back against the mechanical jurisprudence of the formalists. He urged that law must consider its purpose, which he argued is justice, and the actual social factors influencing people's behavior, not just abstract rules.
And Llewellyn, another realist, even took it a step further, didn't he? Suggesting that the rules cited in judicial opinions are often just sort of post hoc justifications for decisions judges have already made based on other factors.
That's a key and perhaps cynical realist insight. Llewellyn famously demonstrated how easily opposing arguments could be constructed using accepted canons of statutory interpretation. He showed how any of 28 basic legal propositions could be argued either way. For example, a statute cannot go beyond its text, versus to effect a purpose, a statute may be implemented beyond its text.
So the rules themselves don't dictate the outcome.
Not always, the realists argued. They had both a descriptive agenda, trying to figure out how do courts actually decide cases, and a prescriptive one, thinking about how ought they decide. They pushed for judges to consider the law's purpose, the specific facts, and importantly, to actively acknowledge changing social conditions.
And this is where the famous Brandeis brief comes in, right? Pioneering the use of social science data in legal arguments.
Precisely. Louis Brandeis, before he was on the Supreme Court, broke new ground as a lawyer by submitting briefs filled with extensive social scientific evidence, statistics, reports, studies in cases like Mueller v. Oregon. He used this data to argue about the real-world social consequences of legal decisions, like the impact of long working hours on women's health.
A very different kind of legal argument.
Totally different. While this approach is now quite common, Ellsworth does note, maybe a bit cautiously, that its actual influence on judicial decisions might sometimes be less direct or decisive than social scientists might hope or believe.
Interesting. So beyond these historical movements like formalism and realism, how does legal reasoning, even today, fundamentally differ from, say, scientific reasoning? Are there core differences in the way they approach problems?
Ellsworth outlined several key differences. While both obviously use comparison, logic, and hypothesis consideration, a scientist is primarily seeking truth and understanding of how the world works. A judge, however, seeks to settle disputes justly and, crucially, consistently with existing law.
Even if there's no simple truth.
Right. Even if there's no empirical test of justice for a given outcome, the goal is resolution and legitimacy within the legal framework.
This sounds like the judge has to make a definitive call, a clear yes or no, even when the underlying reality is incredibly complex, uncertain, and full of nuance.
Exactly. Legal decisions are inherently categorical. Guilty or not guilty, liable or not liable. There's rarely room for maybe in the final judgment. The adversarial system itself pushes for these clear-cut arguments, inherently minimizing ambiguity in the final decision. And you see this in judicial opinions. Judges rarely express deep uncertainty in their published writings. There's a strong institutional pressure for consistency and to project a sense of inevitability, even when the court was actually deeply divided, like in those 5-4 decisions.
And this preference for categorical answers often translates into a discomfort with things like probability or statistical data, doesn't it? Because that kind of evidence doesn't always fit neatly into that yes-no model.
You've hit on a significant tension there. Judges often resist purely probabilistic statements or aggregate statistical data because their core task, as they see it, is to make a yes or no decision about a particular individual in this specific case.
Can you give an example?
Sure. The famous case, McCleskey v. Kemp. The defense presented strong statistical evidence showing a significant racial bias in the application of the death penalty in Georgia. But the Supreme Court rejected it as grounds for overturning McCleskey's sentence because, they argued, the statistics didn't prove discriminatory purpose in his specific case, even if the systemic bias was statistically evident. The focus remained on the individual case, not the general pattern.
That's a stark example. And it also seems legal reasoning still strongly emphasizes individual free will and autonomy, maybe more so than other fields, even as psychological insights increasingly highlight the powerful influence of situational forces on behavior.
That's another profound tension, absolutely. Legal thinking remains, as Ellsworth puts it, deeply rooted in traditional notions of individual autonomy and free will. People are generally held responsible for their choices.
Whereas social sciences often look elsewhere.
Right. Social sciences increasingly emphasize deterministic factors, situational pressures, environmental influences on human behavior. Legal concepts that do acknowledge external pressures, like necessity or duress, are generally reserved for truly extreme situations. This illustrates how the powerful influence of everyday situational factors on behavior is often largely overlooked or discounted in legal analysis.
So it sounds like despite all these major intellectual developments and critiques over the last century, the fundamental form or structure of legal reasoning hasn't changed all that dramatically, even if the content it considers like social science evidence has broadened somewhat.
Indeed. That seems to be the conclusion. It remains a socially defined and socially constructed system that arguably serves its specific purposes, resolving disputes, maintaining order, providing predictability reasonably well, despite its imperfections. While more general scientific research or other forms of knowledge may be incorporated into legal arguments, the core rules of the game of legal reasoning itself, this reasoning by example, this focus on precedent and categorization, seem unlikely to change without a truly major change in the system itself.
We've really peeled back the layers of legal reasoning today, moving far beyond that simple idea of fixed rules and perfect logic. What we found instead is this dynamic, constantly evolving process, one that seems to thrive on ambiguity and requires constant reinterpretation.
And this raises an important question for you, the listener, to ponder. How do we, as a society, actually manage to adapt and apply our core principles to ever-changing circumstances, especially when we inevitably disagree on so much? The very purpose, Levi suggests, for which the institution of legal reasoning has been fashioned is precisely to give meaning to ambiguity, to manage disagreement peacefully.
Right. And as Levi reminds us, this imperfect system, full of ambiguity and shifting rules, is perhaps the only kind of system which will work when people do not agree completely. The law's compulsion, its commands are clear, but that area of doubt is constantly set forth, allowing for a kind of foreshadowing of its potential expansion or contraction. It's a subtle way the system signals its own future direction.
Ultimately, the argument goes, the loyalty of the community is directed towards the institution itself, the process in which it participates. And this allows the words of the law, even fixed words in statutes or the Constitution, to change meaning over time and receive the content which the community gives to them. It's a continuous conversation between the past, present, and future.
So the next time you hear about a legal decision, maybe consider the complex, ever-shifting dance of reasoning by example that likely went into it. Think about how it constantly molds the law, trying to reflect the evolving ideas and needs of society. And maybe ask yourself, what new societal shifts, perhaps things related to artificial intelligence, climate change, or global interconnectedness, might challenge our current legal concepts in the years to come, forcing them to adapt once again?